We are now talking about the state of Florida, which even some of the things that you mentioned about like foreclosure process, it's a judicial process. So it's going through the court system, whereas not all states are like that. So wherever you're listening, make sure you talk to an attorney in that area. But if you're in the Florida, I recommend you talk to Shawn. But so let's go ahead and let's talk about that. What are some of the things that real estate investors need to make sure are set up and recorded or not recorded, or what do they need to do to protect themselves legally?
Welcome to the Jennifer J. Hammond Podcast. Jennifer is a licensed realtor, educator, speaker, and best-selling author. Jennifer's goal is to help you find your yay in every day.
Hello, it's Jennifer. I'm so excited. We have one of my favorites, a real estate attorney here, Shawn Yesner. I always love that your last name. Do you say yes all the time?
No, sometimes I do say no.
So Shawn, for people, if they haven't heard one of your other times you've been on the show, you are one of my favorites. So you specialize in a very unique part of real estate law. And so I want you to tell a little bit about your background and your podcast and how you came to where you are now.
Yeah, thank you. I had a great time the last time I was on. I love being on. Anytime you want to talk about stuff, I'm always open. Let me know. But so when I've been an attorney now since 1998, which, Lord, I feel really old now because as we're recording this, I'm coming up on 25 years as an attorney, and that entire time has been spent in some aspect of real estate law. When I moved here to the Tampa Bay area in 2001, I took a job at what we would call a foreclosure mill. So I was representing banks taking houses away from people, and I was really fascinated by that area of law, and I really got a lot of experience on all the different areas, foreclosures and litigation and appeals and bankruptcies and title and all that kind of stuff. In 2004, that law firm ended up shutting down. And so I decided, well, by that point, I'm 6 years out of law school. And so I just switched sides and started defending homeowners who were in foreclosure. That then led me to my introduction to the real estate investor market. And so I learned all about LLCs and corporations and land trusts and subject to transactions and ABC closings and joint venture agreements and all the different stuff that investors like to have, hard money loans and all that kind of stuff. But as I was representing borrowers, that also led to bankruptcy and helping to eliminate debt. And so now that's really the two sides of the practice. On one side, I have all the debt and helping people with debt and helping people get out of debt. And on the other side of the practice, I have all the real estate stuff. So I actually do have evictions pending. I've got quiet title lawsuits pending. I've got a specific performance lawsuit pending. I've got a lawsuit pending on title issues. I've got all different kinds of real estate. I don't do closings anymore, so I like partnering with title companies. But all the other real estate legal stuff, I can help handle for investors. I've got a couple of foreclosure cases pending right now for hard money lenders. So those are the two sides of the practice.
And I wanted to say today we want to talk about how to protect real estate investors legally, because so often this is the weakness. I want to say, especially for people who have done one or two deals or have done no deals and they're just getting into it. And they so often get burned because they didn't set up the agreements properly. So just to clarify, we are now talking about the state of Florida, which even some of the things that you mentioned about like foreclosure process, it's a judicial process. So it's going through the court system, whereas not all states are like that. So wherever you're listening, make sure you talk to an attorney in that area. But if you're in the Florida, I recommend you talk to Shawn. But so let's go ahead and let's talk about that. What are some of the things that real estate investors need to make sure are set up and recorded or not recorded, or what do they need to do to protect themselves legally?
Well, I think the background issue or the issue behind the scenes here is we never really need these documents or these agreements unless or until something goes sideways. And the best time to get them signed is when everybody's friendly and everybody's getting along. So I think my number one tip would be to get the agreement in writing, get the agreement memorialized in writing. I mean, even to the extent, I like charging on a flat fee basis. And obviously that fee is going to depend on the complexity of the transaction. But typically to draw up a contract, it can't be more than, a couple of $100, even if it's like up to $1,000. I mean, it's not going to be a lot of money relative to if something goes wrong. Some of these litigated cases that I'm working on are in the thousands of dollars or $10,000s of attorney's fees that could have been avoided by a few dollars up front. So I think the two most important things, you get everything in writing, memorialize it in writing when everybody is friendly and when everybody's talking to each other, when everybody's, smiles and working towards the same goals. And to the extent it is appropriate, record the document. And I say that because some documents say in there, don't record them. Some documents you may have privacy issues,
Right.
especially when we're dealing with land trusts and whatnot. So I would say get it in writing and where appropriate, record it.
Well, that's a really, really important one. And I was gonna say, and then what I hate to say it, but on the other side of it, so when things go wrong, what do you do to solve when they go like you? I love the way when everybody's still friendly, because when the stress comes and it gets more and more intense, which happens, especially because of what's happening right now. So now we're recording this in April 2023 of, oh my gosh, the market is shifting. And so no matter where you are, I'm licensed as a real estate agent in Virginia, Washington, D.C., Maryland, and now the whole state of Florida. And every single one of the markets is different. If you're talking about in Florida on the waterfront, or if you're talking as you go inland toward Tampa, same thing with Washington, D.C. DC market in the DC city right now is a little bit slower than the suburbs. The suburbs are much more busy, but if nothing else, the one thing you can say, which I know is the old cliche, the one thing you can count on is change. The one constant is change. So we know we have a changing market right now. What do you do when you're on the other side of a real estate investing deal and everybody's not agreeing and you're trying to figure out how to sort it out?
Yeah, well, in Florida, there's a couple of different options that you have. I mean, the first thing I'm going to do if you call me for a consultation is I'm going to say, what does the agreement say? Send me a copy of the agreement, and we're going to go by the agreement. Now, maybe there's ways that we can attack the agreement. Maybe there's ways that we can show that one side or the other is in default of the agreement. But basically, I'm going to say, step number one, what does the agreement say? Send that to me. If there's no agreement in writing, there is something in Florida called the statute of frauds. And basically it doesn't really have a lot to do with fraud. What it means is if you want to hold somebody responsible for an obligation, there are certain instances where that obligation has to be in writing for you to hold them responsible. So for example, purchase or sale of a house. It's got to be in writing and signed by the party that you want to hold responsible. Otherwise, the statute of frauds in Florida will come in and say, we can't do it. Now, there may be other ways around that. For example, if you don't, let's say you put down a deposit of $5,000 to buy a piece of property and there was no contract and now it falls apart. Well, I can use my bank records, hopefully I didn't use cash. I can use my bank records to show that I gave the $5,000. So I could still file a lawsuit that says, I want my $5,000 back. I may not get all those other damages that a normal contract would allow. I'm not able to collect attorney's fees. Maybe I'm not able to collect interest. Maybe I'm not able to collect, other types of damages. But I still think the law is fair in that if I gave somebody some money and I got harmed by that, I can certainly sue to get that money back. I may not have the contract behind me. So if that tends to be the situation and we have a listener that has some kind of agreement that's not in writing, at least get your evidence together, get your bank records together, get me email communications, get me text message communications. Those aren't going to be as ironclad as if we had a contract, but they're going to help build the story, build the case for the judge.
And what do you think that the attitude of the judge is for that when you're building the case, as you said, because again, it's a story that you're telling. You're sharing this story, and this is the way it went, and now we're at the high drama part of the story of there's a big disagreement, and we're trying to figure out how to get everyone to solve it. Do you think that, like, I know that in Washington, D.C., you could say without a shadow of a doubt, almost all the judges are always leaning toward the tenant. They're always leaning toward, I almost want to say the person who is, in their viewpoint, and I use my air quotes, the more vulnerable. What do you find in Florida? Is there one side or the other they're leaning toward, or is it the story itself? Or
unfortunately, it's kind of all over the place. I've had judges that I've wanted to appeal that the client hasn't let me because I thought the judge was just completely wrong. I have a Florida Supreme Court case that says the judge should do XYZ and they don't, but the client wouldn't let me appeal it. I've had some judges that are very strict on the law and they follow it to the letter. I have some judges that are very strict on equity and fairness, and they go based on that. Even within the foreclosure realm, I tell clients, Florida law says the foreclosure sale, once the judge grants judgment and schedules a foreclosure sale, the foreclosure sale has to be between 28 and 35 days from the date of the hearing by statute. But it's become practice in Florida to say to the judge, can I get a sale date 60 days away? Can I get a sale date 90 days away, 120 days away, whatever? Some judges will say the statute says 28 to 35 days, and if the bank's attorney's not going to agree, then I'll give you a 30-day sale date. Some judges will say, yeah, I'll give you 90 days. I'll give you 120 days, because if I appeal that, if I'm the bank's attorney and I appeal that and I say the statute says 28 to 35 days, judge granted 120, that's not fair. The appellate court's going to side with me because the statute says what the statute says. But by the time the appellate court sides with me, we're 180 days away. The foreclosure sale would have happened already. So unfortunately, our judges, I like our judges. I want to be very, very clear. I think we have some really good judges here in Florida, but unfortunately, they kind of tend to be all over the place. They tend to be pretty consistent, but they each have their own separate leanings and quirks and whatever. So there's no real, I'm going to default to the typical attorney answer. It depends.
It depends. Well, that's why I asked the question, because it depends on the story. It depends on a lot of things. But also what my point is being that it's different depending. Also, it depends on where you are in the United States and what state you're in. And then the nuances just continue of it depends on that answer. And I just have found that from observing all sorts of different legal cases that I've observed, again, from the outside, not being a lawyer. But so let's take the one thing. I think that's a topic that you just hit on that is so important for real estate investors as well. A lot of them are now like, oh, the market is changing, it's falling. So now we can scoop up all of these foreclosures and short sales. And so I'm curious on your viewpoint on that. And also, what does that look like right now in the year 2023? Like in 2020, 2021, even 2022, we were still talking about multiple offers and nobody was even talking about short sales or foreclosures because there were all these moratoriums and all this other stuff. So now we've changed. Now we've turned a corner. So
yeah, I am not seeing a lot of short sales. The last short sale I saw was years ago. I haven't seen a short sale in forever because a lot of houses now in Florida have equity. I think what we're going to see happen is people saying, well, I need to sell my house and cash out because I have equity in it. I can't afford to catch up the mortgage. I can't afford to pay the mortgage, but I can cash out. The reason I think that, and what I am starting to see, is a rise in the subject to transactions. So you own a house, you've got a mortgage on it, you did a good job and you got your mortgage when it was at 3%, but now something has happened and you can't pay your mortgage. Well, I come in as the real estate investor and I take title subject to your mortgage. I'm going to put a renter in there who's going to pay me rent payments that I'm going to use to pay your mortgage payments. That's what I saw way back in 2006 and 7 and 8 before we had the market crash, and I'm starting to see it come back again. So I think that's where that's where we're headed, is a lot of these subject to type transactions, which I get it. There's a couple issues there. Most mortgages, if not all mortgages, have what we call the due on sale clause. And so if the bank finds out that I've taken that house subject to the existing mortgage, they can call the loan due. So you got to be careful with that. It's got to be a situation where the borrower has a lot of trust in the investor, and the investor has to be honest about it, because where a lot of investors got in trouble in the crash was they had all these properties subject to the existing mortgages. They didn't, when the market crashed, they couldn't afford to keep up their payments. And so they said, the investors said, well, I'm not on the loan, so I'll just let it go into default. But what that ended up doing was hurting the original borrower that sold them the house, that the loan was still under that borrower's name. So that's where I think investors have to start to be careful, is with those types of situations.
Absolutely. And I think also just understanding, even as the homeowner, realizing what you're agreeing to, because what happens, as you just said, if the person doesn't hold up their end of the bargain, which is the whole reason that we wanted to do this episode, was just to kind of give some pearls of wisdom. And I think there's some really good takeaways. Number one, always get it in writing. Number two, do it when everybody's still happy and they still like each other, and then when it isn't going right, go ahead. And I think so. And that was part of what my other question was, is so when it all starts to fall apart, this is the time to, how do you suggest, should you find a negotiator? Should you go to court right away? What are the options for someone when it all starts to fall apart as a real estate investor?
I think that's more your own style, your own personality. We do have to go back to the agreement and see, does the agreement require, some agreements might require some type of notice of default or notice to cure, prerequisite. You could jump right to a lawsuit if there's no prerequisite. I know a lot of mediators out there that will mediate disputes prior to any lawsuit being filed. You could do that. There's a couple of different options, but I think part of it, again, it's going to depend on, what does the document say? Does the document say I have to give any kind of notice that you're not living up to your end of the bargain? And then what's my personality? And do I want to jump right to a lawsuit? You can. I mean, there's certainly nothing that says you can't. Just understand, when you jump right to a lawsuit, you've pretty much drawn that line in the sand, because then you've got attorney's fees, you've got filing costs, you've got service of process costs, you've got all that other stuff. At the same time, there's something to be said for the aggressiveness of filing a lawsuit, because if you don't, the other side's just going to sit back and say, Shawn's just going to call me, and I'll wait another month and he'll call me again. And I'll wait another month and he'll call me again. And, there's no real teeth to that. The other thing I would say, kind of a pet peeve of mine, 90% of the time when somebody tells me I have an attorney, they don't.
Yeah.
So when people say to me, I'll just tell them I hired you, I say, well, until you actually do, don't tell them that, because it's rarely true. So, I don't think, unfortunately, I'm as intimidating as I used to be. So saying I've got an attorney may not really do much for you. Either you got the facts and you go ahead and you file the lawsuit, or you file the demand letter, or you ask for the mediation, or you send the notice of default, or whatever it is. But that's how I would start. And again, I do offer a free consultation, cheap plug. So if somebody has a question, they're certainly able to come to me, and I can review the agreement. And does it require a notice before jumping to court? Does it, what else does it require? And we can go over all the particular facts of a specific situation.
And that's the perfect time. I want people to know that you also have your own podcast, so that if you're interested in hearing about the podcast, so tell them about your podcast. And if they're interested in free consultation, maybe your website, phone number, anything you'd like to share.
Yeah. So the podcast is called Crushing Debt. I've had it since 2015. As you and I record this, I'm in the 360s in terms of the number of episodes. It's on all the major, Apple, Spotify, wherever someone listens to wherever they're listening to this show. I'm sure Crushing Debt is there. it more sprang out of the debt side of the practice, the bankruptcy and the debt side, although we do cover some real estate topics from time to time, but the majority of the focus of that podcast is helping people eliminate their debt. And the website is the easiest way is the law firm's website, which is yesnerlaw.com. There's one S in Yesner. Yesnerlaw.com that's pretty much where there's a contact us link. There's the podcast link. There's the link to the YouTube, the blogs, all the social medias are there too.
Perfect. Well, as you know, I love to look at the silver lining in life. So I'm going to ask you to raise your voice and say yay with me as we go off the air. Okay?
Okay.
3, 2, 1. Yay!
Yay!
Awesome. Thank you so much. I appreciate it.
Hi, I'm Jack